Hi guys, it's Kathy. I hope you're doing well. We made it to OJ again. It's Saturday. Today's that one weird day. I am off for 8 weeks, but I have to work today. That's one weird day in between it all, but that's okay. I miss everybody terribly. The next 7 weeks are going to be hard because I miss everybody terribly, but 1 week is already done. I've already made it a whole week, so it's only 7 weeks left. It's going fast. Anyway. Let's start OJ. We are on video number... Oh, geez, the list went the whole way back up to 200. 450... Nope. Sorry, 449. That's crazy.
I'm not sure.
This
You might
is
have,
crazy.
right?
I could have.
That's what you came down here to look at the gloves for, to see if you could find a defect, correct?
I wanted to see if there was any marking in a specific part of the glove that corresponded to a shadow on one of the videos. I wasn't sure whether it was lighting, whether it was a mark. Just wanted to look at it.
To see if there was a defect on the evidence gloves that corresponded to what you saw in the picture.
Correct.
Wasn't there, was it? There was no such defect on the evidence gloves, was there?
I didn't see anything that I could definitely re-identify in any photo.
Now, which picture were you looking at where you thought you saw shadow, defect, or whatever you want to call it?
I don't think that picture was actually used here. It was one of the photos that was thrown out. It was a right hand.
Are you referring to one of the gloves the prosecution decided not to use?
I believe that in an effort to save time, they just started to arbitrarily knock out different photographers and photos.
So the one where you thought you saw a defect, they didn't show to the jury.
Sustained. Sustained.
All right. Now, you've indicated from many of these pictures that it's your opinion that you can identify the 3 points on the back as being the same type of 3 points that is on the ARIS 70263, correct?
That's correct.
Now, you've indicated that's a common backing, correct?
It's very common, yes.
Are there other backings that can be mistaken for that?
I'm not quite clear as to what you mean by that.
Well, let me show you a sheet. True, but take a look at that.
Do you have some foundational questions on this?
Yes. You recognize that as a document that shows various different kinds of stitching that can be used on gloves.
Yes, I do.
Are you familiar with all of those?
I recognize many of them.
You not going to have that mark and put on the elmo, please?
Need a little more foundation than that.
Are all those, there's different kinds of backing stitching, correct? The 3 points we're talking about?
Yes. These are different configurations of what I would call 3 decorative points on the back of the glove.
And you recognize all of those, do you not?
I actually don't recognize all of these.
Okay. So there may be some out there that even though you have a lot of experience with gloves that you're not familiar with.
Well, there's many that are out there, but not necessarily used.
My question was,
Could be.
that some out there that you don't know.
Could be.
And the top part of that diagram indicates different kinds of stitching for fingers, right?
They do, but they're poorly represented in these sketches.
Okay, but you recognize each one of those? I mean, they're described underneath them, are they not?
Yes.
They're all stitches you're familiar with?
I'm familiar with all these.
May I have that mark and put on the elmo, please?
That's 1373. This is Robertson, 1373.
see those sample stitching, because those are the silkings that we've been talking about.
Right.
The 3 points on the back. Which of those, if it's up there, is on the ERA 70263?
These sketches are actually so poor and not really indicative of what they say compared to what's on a glove. If you want me to pull out a glove to show you, like as an example, the bottom right, it says 4 needle stitching. If you want me to pull out a glove and show you what 4 needle stitching looks like, it doesn't look like this. I can't tell. I can't tell from this.
You can't tell from those stitches which one is on the ERA?
The way the draw machine works, there are 5 positions, there are 5 needles. You can configure them to do things in different formats. What's on the back of 70263 is needle number 1, 2, and 3 with thread, without cord. I don't know where it is on here. It's a blur.
Now, if I put 612B on the output.
Yes.
Mr. Rubin, you recall identifying this picture, this is the Gadara picture,
Yes.
and identifying the backing on the glove?
Yes, I did.
Can we back it out, get a little clearer, please? Your testimony that you can tell that backing was made with a particular configuration of 3 needles?
It appears to have a ridge in the middle. The reason I came up with that is it appears to have a ridge or a high-low in the middle of each point, and that's what gave me indication that it was 3 needles. There has to be a needle on the right, a needle on the left, and because it has a ridge look, I think there's a needle in the middle, and that's what gave me that conclusion.
You see that as 2 lower lines and a ridge in the middle?
Objection, Your Honor. You can look at it on the Alamo.
Well, is
You,
there,
you have to remember, I've had the opportunity to look under this photo with a magnifying glass.
Mr. Rubin, we're talking about these pictures that the prosecution offered. Are you telling me from that picture you can see 3 lines of stitching?
Objection, Your
From
Honor.
this picture, I can't see anything.
How about from the picture itself?
From this picture, I see a ridge in the middle of the point, which indicates the 3rd needle.
And just so we're clear, you're saying that in that picture, or are you saying that you can identify for each of those 3 lines in the backing that for each line has 3 needle stitches in it?
Left, right, and center, yes.
Now, is that something you can see in that picture?
In my opinion, I can see it.
Do you accept how other experts might differ with that?
Sustained.
Now, in one of these pictures, in the Renkin pictures from '91, you identified water spots on the gloves?
That's correct.
There are no corresponding water spots on the evidence gloves that correspond to the water spots on those gloves, correct?
I'd have to relook at it again, but I don't think that I could even make any judgment regarding to those particular water spots as to how they relate to a glove today.
Well, all right. I asked you yesterday, did I not, that if you got water spots on a glove like that, they might stay there, right?
For a brief period of time.
Did you say brief period of time?
Yes, I said to you that as the gloves were worn again and stretched out, they would dissipate.
You didn't tell me that sometimes they would stay?
To refresh your memory, Mr. Blazier, I also pointed out that if someone with these Aris Lights gloves, which were truly naked leather, were to wipe their brow and get oil on their finger, the oil would stay on the glove for a brief period of time. But gradually, as the person wore the gloves or moved their hands back and forth, the oil would dissipate.
You didn't tell me that water spots like that, you told me that they might dissipate, but they also might stay there, didn't you?
I don't remember saying that.
Now, could we have frame 4748? I think I may have given you the wrong number. 4582, I'm sorry.
Mr. Harris, do you need Mr. Fairwell's assistance on finding that?
Well, they're not in the order.
Mr. Ormond, let's take this down until we find the right frame. Thank you.
Yes.
All right.
Remember looking at this frame before, Mr. Rubin?
Yes, I do.
Now, I believe on your direct testimony, you testified that from this picture, you can identify the Brosser stitching on the fingers. Am I correct in that?
I don't believe I would have used this one for the Brosser stitching.
Okay. But you would use this one for the 3 lines on the back?
I believe this one was used for the palm vent on the left hand.
Okay.
Was the primary purpose.
Now, would you agree that the picture on the monitor is a lot better than the big screen?
Surely better from here, but not as good as the monitor in the back.
Do you see, looking at the monitor, what appears to be a bulge in the palm of Mr. Simpson's left hand under the glove?
I don't detect a bulge.
You cannot see a raised area, what appears to be a raised area right in the palm between the thumb and the fingers.
There's a shadowy effect. It could be slightly raised. I don't know. I really don't know what it means.
Do you know what a heat pack is?
Yes, I'm very familiar with it.
And people use heat packs to put in the palms of their gloves to keep their hands warm, don't they?
I'm familiar with it.
And that's going to cause a glove to stretch, isn't it?
It could. I'm not familiar with what size heat pack we're talking about.
Okay. You take that down, please. I take it, Mr. Rubin, you would agree that you can exclude the gloves in the West pictures as being the evidence gloves in this case.
Due to the color, yes.
And you can exclude the Romano gloves, correct?
They appear to be black also.
And you can exclude the Kruger pictures, can you not?
Same thing, yes.
Now, I think your testimony was that you can read writing on whatever this is in the photograph?
You can answer the question.
I clearly stated that I could not read the writing on that tag.
All right. But you can see printing on it?
I can see that there is something on it. It appears to be printing. The tag, what I stated is in the shape of the Aris Rospatch label tag. It appears to be beige in color. It appears to have some kind of burgundy printing on it, which is the same as what was used on all Aris tags.
Now, looking at the Gadara picture again, can you see it from there? You indicated on direct, did you not, that you thought you could identify the Brosser stitching on the fingers in that picture, did you not?
On the left hand, on the top ridge of the finger, is a very fine ridge, and that would be the only spot that I could detect it from that glove.
Can you come and show me where you're pointing, or where you're indicating?
Is that the index finger?
Forefinger.
Forefinger?
Do we have, Your Honor, do we have one of your little arrows? Or? May I put a stick on it? I'll put it right above here. You're talking about the first finger, where you see a ridge that you can identify as the Brosser stitch?
At the end of the finger, there's a very fine ridge, fine line, which appears to be similar to a Brosser stitch.
Well,
And that's why I'm saying it's a Brosser stitch.
okay, so from my arrow, we're actually looking at the end of the finger itself?
No. I would put the arrow over here, toward this edge.
But I mean, yeah, the end of the finger.
End of the finger.
Okay. And you can see a ridge there that enables you to identify that that's 22 stitches per inch.
I cannot see 22 stitches in that one specific spot, no.
But you've identified that as the Brosser stitch, have you not?
It is similar to what a Brosser stitch looks like, yes.
Now, you indicated before that you were able, in your mind, you were able to make a positive identification of that style glove from that picture alone, did you not?
Zach,
I didn't say that.
Zach, stop talking in chat. We're trying to learn here. We're trying to learn about the stitch on the end of that glove. Come on, Zach. What are you doing? This is intense stuff.
What I said was the elements that I could see were part of the elements that make up style 70263. And once again, there are no elements that lead me anywhere else.
Is it your testimony that that a Brosser stitch is the only stitch that would look like that in that picture, in the Gadara picture?
Any other whip stitch would look similar, but to someone like myself or someone who made a lot of Brosser sewn gloves or was very cognizant of what a Brosser sewn stitch looked like, it would look slightly different.
Is it accurate that you cannot offer any opinion at all as to the shades of the colors of the gloves in the pictures, the brown gloves, vis-a-vis the evidence gloves?
I can make no attempt whatsoever to determine the photographs as far as colorations due to the fact that in my own experience in making packaging as well as all the advertising that we did with various stores that we never really were able to get the color of the gloves correctly in print, packaging, etc. I wouldn't make any conclusion regarding color in these photos.
Now, in this particular style, Eris actually had two different kinds of brown, correct?
That's correct.
And one was called a brown, the other was called a mink.
That's correct.
Were there any other terms used for those?
Mink or medium brown,
What colors are the evidence gloves,
brown,
as opposed to medium brown?
or mink, yes.
And how about did you see any pictures? Well, let me ask you this. Can you tell whether the pictures that you saw, that you testified about, are brown or mink?
They're all within the brown family, but no two pictures are alike from any of the photographers.
So from the brown pictures in the photographs, you can't say that they are the same shade or necessarily the same color as the evidence gloves. Is that correct?
To my best
I've been
recollection,
sewing since I was
color
an itty
mink
bitty.
was so reddish and lighter in color that it would not be
Not
in any of the
quilts,
photos
though.
would they be mink.
Not
These,
quilt. I made
these
one
photos all
quilt.
reflect brown gloves that I've been shown.
Okay, so none of the photos that you've seen, in your opinion, could be mink.
That's correct.
You remember when you gave a statement to the prosecutors on August 29th?
Over the phone?
Yeah.
That's correct.
Did you know that was being taped?
Yes,
Did you know that they made a transcript of it?
yes.
Have you seen that transcript?
I have not seen the transcript.
Do you remember when they were asking you that you had the one of the Renkin pictures, that's the umbrella pictures,
Yeah,
brown glove?
right.
They asked you what color it was? Remember what you said?
That color is the closest to mink of what mink would look like.
Do you remember
That's
what you said?
I don't remember 100%.
Do you remember saying, I am not quite sure whether they are really what was called mink or dark brown, but they are definitely a shade of brown?
I'll stand by that.
So when you were looking at these pictures on August 31st, you weren't sure whether they were mink or brown, were you?
Objection.
The Rankin pictures.
Rephrase the question.
When you were looking at the Rankin pictures, you had them on your end of the phone, you were talking to the prosecution on their end of the phone, you told them you couldn't tell whether that was brown or mink, correct?
That's what I said.
Now you're coming here in your testimony, you're now saying can't be mink. Is that right?
Well, the reason I'm saying that is because I actually called the photographer myself to ask him
Yeah.
about the coloration, and he more or less led me toward the indication that his color was could be slightly off.
You thought they might have been mink when you saw them before. It's the same picture, isn't it?
Could be.
It is the same picture, isn't it?
I believe it's the same. Or a copy.
You testified on direct here today that, in your opinion, the gloves in these pictures are a snug fit on Mr. Simpson?
That's correct.
Let me ask you to look again at the Gadara picture. Would you agree that the leather seems to be bunched up around the fingers?
On the right hand in that particular picture, his hand is arched slightly backward, and that's the effect you would get on a leather glove. On the left hand, it appears to be more like a normal snug fit.
Would you agree that between the Gadara picture and the Renton picture 3 years earlier, the gloves appear to be bigger in the Gadara picture on Mr. Simpson's hands?
I think I would be speculating.
You're not willing to make any kind of assessment for looking at the photographs on that point?
All you've done is speculate, sir.
It appears that in the Rankin picture, Mr. Simpson has his hand a little farther around the microphone. His knuckles are a little bit more to the left of the photos. It would be difficult to say that I could tell the difference between the exact fit between the two photos.
Isn't it your opinion that the gloves in the pictures that you've been shown in this case are either a regular extra large that fit Mr. Simpson or an oversized extra large?
That's correct.
So from the pictures, they appear to be possibly too big for him.
Yes.
There are no pictures where the gloves appear to be too small for him. Would you agree with that?
The only thing that you see in the pictures regarding small is on the shortness where he wears the gloves, but I don't see anything in the finger area that indicates they're too small or around the back of the palm.
We have the Bloomingdale's receipt. Do you still have it?
All right, Mr. Glazier, what exhibit is that?
This is 372B. Actually, let me use 372. Trying to figure out which one's better. Let me try 372B.
$230.
Okay. Now, Mr. Rubin, you've seen this receipt before, have you not?
Yes, I have.
And can you tell from that receipt, let's assume they were gloves, what color they are?
No, I cannot.
Can you tell what size they are?
No, I cannot.
There were, I think you testified, 1,000 dozen or 12,000 pairs of gloves that were ordered by Bloomingdale for this particular season, correct?
That's correct.
All that had the same style number?
That's correct.
And you had been producing those gloves with those same characteristics
A
for 10
thousand
years?
dozen.
Not 10 years.
From 1982, I'm sorry, as of 90, it had been 8 years, correct?
Yes.
And then they produced them for several years after that.
I believe about a year and a half.
Now, I think you indicated when you testified before that they started slow and then increased to 1,000 dozen a year for a period of time. Is it fair to say that a rough estimate of the number of these gloves sold to Bloomingdale's during that period of time? 40, 50,000 pairs?
No. I would
30?
say, if I had to speculate, that the quantity was more in the range of around 2,500 dozen for the 8-year period, with the bulk of it being in the last two.
2,500 dozen is
30,000 pair.
30,000 pair. And 10,000 pair, 12,000 pair in the last year?
That was what was originally contracted for. I'm not sure if they took them all in for sale.
So are we talking 40, 50,000 pair, maybe?
Overall.
I think it's closer to 35,000 pair totally from the time they started buying them until the time I left in 1990.
Couldn't he have just
And
asked that question
How
at
many
the
different
beginning?
colors are there?
I believe we made 5.
And how many different sizes?
4.
So would it be fair to say that there were 20 different combinations of that style number that you could get?
There were 20 SKUs,
Okay, so 20 different possibilities that someone could purchase if they bought these gloves.
size and color.
Only one of which would be extra large brown.
That's correct.
The other 19 would be something different than the evidence gloves, correct?
That's correct.
And you had no way of knowing whether these are receipts for that 1 out of 20 or something in the 19 out of 20, correct?
I do not.
Now, this receipt doesn't even have the style number, 70263, does it?
No, it does not.
So if you accept that the receipt is accurate, these aren't for Eris Isotone or leather lights, are they?
I think that this has been covered in previous testimony
I'll give you a chance to explain, but the question is, if you look at the receipt and look at the numbers, that's something other than Eris leather lights, correct?
Overruled. Oh, the jury sat through this.
that particular style.
Hold on. Ask another question.
You can't tell these are Eris leather lights from this receipt, can you?
I actually can, but no one else except the buyer and myself could. Because the receipt states the manufacturer, the fact that it's leather, and the price. And the only thing sold at Bloomingdale's that year at that price happened to be the Eris light style.
How do you know that?
Upon review with the actual buyer of all the styles that were sold to Bloomingdale's by Eris that year, all the gloves retailed at different price points.
Did you hear Ms. Bemich's testimony about whether there were other gloves on sale for that price?
Yes. After she testified, though.
Would you agree that she would have more information about that than you would?
Not necessarily in regard, no, I would not.
In order to assume that that receipt is for Eris leather lights, you have to assume that some mistake was made, correct?
That's correct.
And you have to assume that what should have been on there was something other than what was put on there.
That's correct.
You cannot say, can you, Mr. Rubin, that whatever this receipt is for is the evidence gloves in this case, correct?
No, I cannot.
You cannot say that whatever is in that receipt is in any of these pictures, can you?
No, I cannot.
You have no information about the habits of Nicole Brown Simpson with respect to buying gloves for other people, do you?
Absolutely not.
You cannot say, can you, Mr. Rubin, that the gloves in the pictures that you've seen are pictures of the gloves in evidence, can you?
I can only state that they are the same style and color. I cannot state that they are the same pair.
Now, I believe you identified the lining in the Romano gloves. I'm sorry?
Romano photos.
Romano photo. You've identified that lining as cashmere.
Yes, I did.
Doesn't 100% wool look very similar to that?
No, it doesn't.
How about a combination of wool and cashmere?
It would look slightly lighter.
Slightly lighter in color?
Yes.
So you're stating unequivocally this is cashmere because of the lighting in this photograph?
It appears to be a darker shade of brown than I'm used to seeing in a combination wool and cashmere blend, and for sure it is not a wool blend.
So now you're giving us an opinion based on the shades in a photograph.
I'm only comparing the shade to the shell of the glove. If we're going on the basis that the glove is black, I'm comparing the shading of the lining to the glove.
We don't throw shade in this chat, please, sir.
Could it be a synthetic acrylic?
Except for
I have not
that one
seen
channel.
acrylic that looks like that, but anything is possible.
That was mean to Bill. We
You've
throw
made no
shade
effort
at
other
them.
than contacting two glove companies to find out if there are other gloves out there that have the same characteristics as these Eris leather lights. Have you?
Overruled.
I have not contacted, I don't know, let me just say this, I do not know of any other people to call, other than the two largest competitors to Eris.
You don't know how to find all of these 100 or so other glove companies around the world?
If you want to pay me to do that, I'll be glad to do it.
You know where they are, don't you, Mr. Rubin?
I really do not know where they are. I would go to Milan, I would go to Naples, and I would start to find out where all these companies are, but I'm not going to do that on my own.
And you made no effort to do that, did you?
No, I did not.
No further questions.
Mr. Dart?
Thank you. I put 372A on the album run. Can you zoom back? Let's focus on the right-hand side of the, looking at your monitor, sir, do you see where it indicates muffler? Indicates that a muffler was purchased? at Bloomingdale's on December 18, 1990?
Yes,
At the same time that Nicole Brown purchased 2 pairs of gloves?
yes.
Yes,
All the way
it's
to
on
the
there.
right, MUFF.
It's on there. Hold on. There was testimony to that. Next question.
You understand that as an exhibit in this case?
Yes.
Take that down.
Yellow Solo Cup just breaks the whole song, doesn't it? It doesn't even sound good, that song.
Let's go to frame, let me ask you to look at that photograph.
Yes.
You understand this is a photograph from January 6th or 5th, 1992?
It's a video.
All right, that's frame number 25862.
Is the defendant wearing a muffler in this photograph?
Yes, he is.
That's the thing around his neck.
Yes, it is.
Does it appear to be brown?
Yes, it is.
And the gloves he's wearing, do they appear to be brown?
Yes, they appear to be.
You don't know whether or not Nicole Brown purchased the defendant a muffler and 2 pairs of gloves on December 18, 1990 at Bloomingdale's, do you?
Sustained.
When you first saw the photographs that you were shown and those photographs that were sent to you, you looked at those photographs under a magnifying glass, is that correct?
Yes, I did.
You wanted to be certain of your opinion?
Sustained. Rephrase the question.
Did you want to be sure that you were correct when you gave an opinion?
Yes, I did.
And toward that end, you called a couple of manufacturers, glove manufacturers.
Yes, I did.
You contacted one of the photographers, Mr. Rankin.
Yes, I did.
And why did you contact Mr. Rankin?
I basically just wanted to find out how accurate his color was, if it could vary, because the gloves were like a medium brown. They weren't as light as what mink was, but then again, if it was really mink in the picture and his color was dark, they could have been mink. But basically, he indicated that he could be slightly off, so I just ignored plus or minus.
And this is information you wanted to have so that you can make sure that you provided this jury the most accurate testimony you could.
Sustained.
Were you interested in providing this jury with the most accurate testimony that you could
Absolutely.
and the most honest testimony that you could?
Yeah, yes.
Would you agree that the best test to determine whether or not the gloves in the photograph are mink or brown is to have the jury take a look at those photographs and compare them to the crime scene gloves and the new gloves tried on by the defendant?
At this point in time, the crime scene gloves are almost unrecognizable as far as color, size, texture. It would be very difficult to compare them. However, newer gloves or less used gloves, I think it would be important that the jury see the stitching up close on the gloves.
Let me show you what has been marked 401. One of the new gloves the defendant tried on. What color is that glove?
Brown.
Can you have the jury take a look at 401 as well as one of the Rankin photographs? Compare the colors.
Which Rankin photograph?
Which one would you prefer? This would be 606B.
All right, you want the jury to look at the photograph and compare the brown glove?
Yes,
401.
yes.
All right, hand it to juror number 1, please.
And before I do that, the crime scene gloves, do they appear to be brown also?
Yes, they are.
All right, and after we complete the view and examination by the jury, we'll take a brief recess. Mr. Dart. As soon as the jury completes their examination comparison of the photograph in 401, we'll take our mid-afternoon recess.
Cosmic, I'm in Pennsylvania and it was 60 degrees yesterday. 60. And it was raining. Thick fog. Thick fog. All that rain should have been snow. We're in January. It all should have been snow.
All right, Mr. Darden, would you collect those items from Deputy Long, please?
39 here now.
I was just asking you to collect the items from Deputy Long. All right. Ladies and gentlemen, we're going to take our mid-afternoon recess. Remember all my admonitions to you. Mr. Rubin, you may step down. You're ordered to come back in 15 minutes.
We're talking about 3 gloves that are
All right.
very, very similar.
Shown to them? No, I mean, further testimony, I would object to further demonstration.
Well, the issue of color has clearly been brought up, though. All right, let's have the jurors, Deputy McNair. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Mr. Richard Rubin is again on the witness stand undergoing redirect examination by Mr. Darden. And counsel, if you recollect, we need to conclude before the jury today at 4 o'clock due to some doctors and dentist appointments.
I only have 5 or 6 more minutes, Your Honor.
All right,
Just that
Mr.
long.
Darden, you may proceed.
Thank you. Mr. Rubin, you testified regarding the issue, or on the issue of whether or not you saw any defects or anything unusual in the gloves shown in the photographs. Is that correct?
That's correct.
Did you see anything unusual on the gloves shown in the photographs?
No, I did not.
You saw a shadow, you say?
On a video.
Okay. Was there any defect at all in any of the brown gloves shown in the photographs shown to the jury that you saw?
Nothing that I could see.
And was there any defect that you saw in the Rockingham glove?
Nothing that I could see on the back.
How about the Bundy glove?
Nothing.
Okay, so there's no defect that you saw on the Rockingham, Bundy, or gloves shown in the photographs here in court today?
No, nothing.
But you were checking to see.
I was looking, yes.
You've been careful?
I tried to be as careful as possible.
Do you have anything to gain? Have you spoken to the press or to any tabloid?
I've chosen really
Hey,
not to do
YouTube.
anything in that manner whatsoever. I'm really just here to tell about the gloves in respect to all the details of the gloves, and that's really all I can bring to the table here.
Okay, and the Rankin photograph that we just passed along to the jury, that was the photograph that when you were concerned, or where you were concerned about the mink or brown coloring, is that correct?
Since day one, you're well aware that I've worked with you in regarding my testimony here, and I've
Sustain. Ask another question. The answer was non-responsive.
When you saw photographs back in July, did you ask to see other photographs or additional photographs?
yes,
Did you ask to see additional videotape?
yes, I did.
Did you ever ask to see photographs with more clarity?
Yes, I did.
And why did you ask to see those things?
I wanted to be as accurate as possible in any statement that I might make before this court.
Now, you are from the state of New York, is that right?
I live in the New York area. That's correct.
And when you said that the crime scene gloves seemed to have been worn infrequently, what did you mean by that exactly?
I was somewhat surprised that with the wear and tear on the Rockingham glove, that the lining seemed so close in similarity to the Bundy glove when I first saw them for the first time, because the Rockingham glove was very distorted and somewhat mutilated. I was actually somewhat taken by surprise when we did open up the glove and found out that it was a pair, and the only thing that connected the two was the same wear and tear in the lining, because there is a big difference currently between the Rockingham glove and the Bundy glove.
Now, you don't know what testing procedures or what tests were applied to the Rockingham and Bundy glove, do you?
I do not.
You don't know whether or not samples were cut out of the gloves.
Sustain.
At any event, you don't know what, if anything, any criminalist may have done to these gloves. Is that right?
No foundation.
I do not. My observations were just part of the linings that I could see clearly certain areas of the lining on both gloves.
Now, when you testified that the brown gloves shown in the photographs and in the video were Aris style number 70263, were you forming those opinions based solely on a single characteristic of the gloves that you saw?
No.
Was it based on two characteristics?
Many characteristics.
Or was it based on all the photographs and all the video that you saw?
My complete analysis of these photos was a collective effort. As we well know, there were many that I rejected because I couldn't see enough, and some of them were included in evidence here today, which was sufficient enough for me to state that these photos represent the characteristics that are part of style 70263.
Mr. Blazer asked you about
Thank
heat
you,
packs.
Cosmic
Yes, he did.
Jaden. Thank you.
Would the use of a heat pack cause the gloves to shrink or expand? That is, assuming they were dry.
Technically, the worst thing that can affect the size of a glove is a combination of water and heat. Generally, water first, heat second. If the gloves were wet at any point in time and a heat pack,
No foundation.
Sustain. Foundation.
Okay, well, what would happen if there was a heat pack in the glove and the glove was wet?
Foundation. Counsel.
You've already testified about shrinkage and what causes gloves to shrink. Is that correct?
Beyond scope.
yes, I have.
Testified to the effect or impact water would have on these gloves. Is that correct?
That's correct.
And we see that in the January 6, 1991 photograph, and in the photograph we just showed the jury, the brown gloves are wet. Is that right?
Slightly wet.
Let's assume for a moment that there was a heat pack in the glove, one of those gloves on January 6, 1991, while the glove was wet. What effect would that have on the glove in terms of shrinkage?
Depending upon the amount of liquid and the location of the heat pack and the actual temperature of the heat pack, it could speed up some slight shrinkage.
And you can't tell us what effect blood will have on a glove in terms of whether it will cause it to shrink, and if so, how much. Is that right?
Objection.
Sustain.
Do you know what effect blood will have on these gloves in terms of shrinkage?
Sustain.
Objection.
Sustain.
I'm sorry, have one more. Ms. Clark has asked me to ask you when football season ends. Do you know,
I'm very familiar with the football season since we advertised during it.
ends around late January, does it?
Starts middle of September, goes through the end
Your
of
poor
January.
azalea is about to get very
Now, when we passed
cold.
around that Bill Rankin photograph, did you want the jury to,
Sustain, not an appropriate question.
I observed,
Hold on, hold on. Not an appropriate question.
well, the photograph that was passed around, did you select that photograph?
yes, I did.
Let me show you the photograph that was taken by Deborah
Maybe put a
Guerrero,
bag on it.
exhibit number
I don't know.
612. As well as the glove the defendant tried on, exhibit 401.
Has to be ice cold.
This particular
water,
photograph and this
salted.
particular glove are
Ice
extremely
cold.
close in actual color.
And showing you what has been marked as 164A, the glove found at Rockingham's, glove found behind the defendant's home. Both of the gloves in your presence and in front of you, as well as the glove shown on the defendant's hand in these photographs, are they all brown?
Yes, they are.
Do they appear to be mink at all? That is, any of the gloves as well as the gloves shown in the photograph?
No, these three gloves are categorically brown.
Now, the glove was exclusive to Bloomingdale's, correct?
That's correct.
Okay, and there's no Bloomingdale's west of Chicago, is that right? You don't know how the 70263 got here from back east?
Calls for speculation, yes, sustain.
Your Honor, I have nothing further. I would ask, however, that the jury be allowed to take a look at the Guerrero photograph as well as the crime scene glove.
All right, my concern, though, is still the, how do you propose we do that?
There's a,
Put all three in a bag.
Well, no. Ms. Clark, I'm sorry, Mr. Darden, let's, loan me the Elmo gizmo. All right, you lay them on the Elmo gizmo there. Lay them out, please.
Here, Marshal.
All right, and would you hand that, please, to juror number 1? All right.
there's no adhesive on the gloves.
Madam Reporter, gizmo. All right, Mr. Darden, would you collect the exhibits from Deputy Long? Mr. Glazier, do you have any recross?
Mr. Rubin, it's your testimony that, in your opinion, the evidence glove is the same shade as this other glove?
Very, very close.
And you can tell that much about the color of the evidence glove?
The back of the evidence glove I was using as a reference.
You feel you can tell that much about the color of the evidence glove?
I can only tell you what I see.
You remember when Mr. Darden just started his redirect before the break? You remember stating, at this point in time, the crime scene gloves are almost unrecognizable as far as color?
That's correct. That's what I said.
Now, right before the break, we passed to the jury the Renkin picture and 401. You recall that?
Yes, I do.
And is your opinion that the shade of gloves in 401 is the same as the Renkin picture?
From this photo, the actual shade is a little washed out because of the flash, but I can detect a little bit more of the color by seeing the difference in the raindrops and whatever, but it's not exactly as, it doesn't appear in the picture to be as dark as this in the picture.
This is picture number 4758 that you were shown, is it not? It's written on the back.
That's correct.
On August 31st, when you were interviewed by the prosecution, which picture was it that you thought might be mink?
I believe it was 4758 and 4748.
Same picture, right?
Yes.
Heat packs. If I understand your testimony, you think that if you have a heat pack inside the palm of your glove, that would cause the glove to shrink if it was wet?
I'm not qualified or knowledgeable enough about heat packs to tell the effect. If there is X amount of excessive heat and the gloves were wet, the two worst elements that would make a glove shrink are being wet and then having excessive heat. And what I mean by excessive heat is anything above normal 68 to 72 degrees.
The gloves are on your hand, and the heat pack is in the palm, and it causes the gloves to dry before they're taken off. They're not going to shrink while they're on your hand with the heat pack in there, are they?
Objection, no foundation.
Are they? I'm sorry.
You can answer the question.
I wouldn't think so.
So wouldn't you agree that the heat pack is going to cause the gloves to dry quicker before they're taken off so that they're not likely to shrink when they're taken off?
Objection, no foundation.
Can you answer the
It's,
question?
it's possible.
Now, the Rankin pictures and the Gadara pictures are 3 football seasons apart, aren't they?
I believe they are.
And there's no sign of any shrinkage at all. In fact, the Gadara picture, the gloves look bigger, don't they?
Objection, that's all special.
Oral.
Calm down.
It is. Rephrase the question. Hold on. Rephrase the question.
The Gadara gloves, at least from the picture, look bigger than the Rankin gloves, don't they?
It's very difficult for me to establish the exact size of the gloves in the Gadara picture. I've seen many Rankin pictures, so I have a better feeling. And I also have seen video of the same game of the Rankin picture, so I have a much better grasp on that particular date and time.
Now, you've testified that you've been the most accurate and the most honest that you can.
I've done my best.
Now, in your search for accuracy and completeness, you've been trying to be as complete as possible?
Objection, that's all.
Sustain. Rephrase the question. It's vague.
After you called the second glove company and found out that they had this equipment, you stopped looking, didn't you?
Do you want me to?
Sustain. Sustain. It's already been asked.
Were you concerned that if you looked any further, you might not be invited to the victory party?
That's ridiculous.
No further questions.
Anything else, Mr. Darden?
Subject to recall.
Well, let me see counsel over the sidebar with the court, please. All right, thank you, counsel. All right, ladies and gentlemen, we've completed Mr. Rubin's testimony. Mr. Rubin, you may step down. Thank you very much, sir. All right, ladies and gentlemen, at this point, I have, with regard to the next witness, I have a couple of things that I need to resolve with the lawyers. And as I mentioned to you, we have a couple of juror activities that need to be attended to this afternoon. So I'm going, as far as you're concerned, we're going to quit at this point. As far as the lawyers are concerned, though, we'll be in session probably till about 6 o'clock tonight. So we'll be here working. Remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Using a lot of notebooks there. Don't let anybody communicate with you with regard to the case. What did I forget? Oh, don't conduct any deliberations till the matter's been submitted to you. All right, as far as the jury is concerned, then we'll stand in recess. We'll stand in recess for about 10 minutes, and then we'll reconvene on some of the other legal issues. All right, thank you, counsel. All right, after we have finished with Mr. Rubin, and I take it that concludes the prosecution's representation regarding glove evidence, is that correct?
With the provision we indicated at sidebar.
Okay. And it's your intent then to move on to Mr. Sims, and you wish to present evidence regarding the RFLP testing and the Bronco, correct?
Yes, sir.
What do you intend on going after that?
After that, we're going to present, and we have points of authority, Hank will be coming down, to present the videotape of final apparatus pursuant to evidence code section 1202.
All right, we'll have to have a hearing on that.
I think it won't take long. And the video itself, Your Honor, is I think 15 minutes.
Okay.
And we need to be heard on the Bronco fiber evidence.
All right, well, I'm sorry.
And Donovan.
All right. Dutton, I take it the defense is going to present their P's and A's Friday?
Yes, I indicated to the court that Dean Holman was returning to the Bay Area to present his P&As for Friday. We thought we'd argue that on Monday, if necessary.
Your Honor, that's not acceptable with the people, because we expect to rest before then.
If they're true to that, I'll ask Dean Holman to fly down here Friday afternoon. But as you said, they're being overly optimistic. The court gave him till Friday, said his materials were up there. If they are moving along, if the court excludes any evidence in this case, we'll move it up. But he needed until Friday. Besides that, we haven't rested anyway. We'll have some witnesses for him by Thursday anyway.
All right. All right, so we have the hearing on Dunton, or is it Dutton or Dunton?
Dutton.
Okay.
Dutton.
All right, I have not concluded my examination of the RFLP issue. I had all the exhibits that were referenced brought up. I have them in my chambers now, and I've been busy all day, so I haven't had a chance to look at them yet. I mean, I've looked at the exhibits. I have not reviewed the Gertie's testimony that was referred to, so I'm not prepared to rule on that at this exact moment. If we break early before 6 o'clock today, then hopefully I'll be able to get to that and issue a ruling by the end of the day.
All right, Your Honor,
All right, then we might as well move on to then the next issue that you wish to present is the Paratus issue.
Correct.
All right, you ready to proceed to that?
Yeah, can we say something here?
Your Honor, in terms of ready to proceed, I don't think I can be ready to proceed when I'm just told for the first time now that the people are about to present to the court points and authorities. I'm going to want to respond to the points and authorities.
This is as to Paratus?
Yeah, they just said to you, I never heard it until 2 minutes ago, they just informed you that they intend to come down here with points and authorities.
No, we intend to argue orally. We broached this issue
I'm sorry.
a month or so
There are no
ago.
written points and
All right.
authorities?
No.
Oh, then we're ready to argue.
All right.
There's another issue, at least, that would be of some relevance to us with regard to the problem I spoke to Your Honor about earlier, the jury problem, and I need to address that as soon as the court will allow me to. We filed one motion, and there's another one that's coming in now that we want to file regarding this because this will require some immediate action on our part, so it's some urgency.
Well, we've had our discussion.
Well, no, we've had a nice discussion, but you said I can bring it up again at 4 o'clock because there's some remedy I wanted to ask the court for before we take our next step.
All right. Well, we'll take it up as soon as I finish these other evidentiary matters. All right.
Your Honor, given the fact that the prosecution may well rest its rebuttal case on Thursday, and at which point we would urge the court to urge the defense to proceed and complete its case, we would like some discovery of the proposed
Well,
witnesses.
Let's
I want to end
finish.
this case this week, Your Honor.
Why not?
The jury
I
is
understand.
tired. We're all tired. It's enough monkeying around. We've got our witnesses ready to go.
Counsel, all I'm doing is saying what issues I need to resolve so you can conclude presenting your case. All right, I'll hear argument on the Paratus issue.
Your Honor,
Okay, Mr. Goldberg is prepared on that, Your Honor. I didn't know you were going to proceed with that at this
Your Honor,
moment.
just one thing you should put into the scheduling, and that
Yes.
is we still not have, I'm fairly astonished that Ms. Clark truly believes she's going to rest her case when they haven't turned over the materials that's supposed to be the subject of Mr. Diedrich's the report, and we have a pending application to have an opportunity
Well, that
to look at it.
indicates to me that since today is Tuesday, we may not see it.
Well, I mean, if we never get to see it, they want to rest, it's over with, so we'll move. That's fine with me.
We turned over Mr. Diedrich's reports, Your Honor.
Well, counsel, no, we're not litigating this now, counsel.
Right, it's just an issue for you to consider.
All right,
that
get
I have
Goldberg.
a pending application.
Get Goldberg down here.
You also mentioned earlier today that we could also address the scope of rebuttal issue. Carl Douglas is prepared to address that issue. Remember,
Well, we're taking this issue by issue, counsel.
oh, okay, I just wanted you to include that in the
Oh, no,
basket of
this-
issues for this afternoon.
All of these issues are scope of rebuttal issues.
Thank you, Your Honor.
While we're waiting, does the clerk want me to proceed on the other one, do something? While we're waiting for Mr.
No.
Goldberg?
Actually, why don't we take the time, while we're waiting for Mr. Goldberg to arrive, why don't we at least view the proposed videotape? Because we're going to have to do that anyway. All right. Do you have it? Ms. Martinez, do you have that? All right. We'll mark this people's next in order. 6:15. Are you offering an instruction with this, Ms. Clark? Are you offering an instruction? Are you offering a limiting instruction with this?
Yes, and that's why Mr. Goldberg's coming down. It's an instruction that limits its use for impeachment, not for the truth of the matter, I believe.
All right, this will be People's Exhibit 615. All right, Ms. Martinez, do you have that? All right, let's see it.
Photographer Teresa Ramirez, and this is going to be a videotaped interview. Thano, Thano, Paredes, P-E-R-A-T-I-S, it's July 27th, 1995, and the time now is approximately 3:48 p.m. Again, this is just a backup tape for the videotape that we're going to tape. Okay, tape reads on the video for 30 seconds.
Very good. Basically, what I wanted to do is just ask you about three statements that you made at the preliminary hearing, and we'll go through those one at a time. And the reason for videotaping, as I said before, is because there was a certain demonstration that you had wanted to show us would probably be better if we had a videotape than if we just did it with an audio tape or some other way. If you want to stop at any time or you feel uncomfortable, for any reason, just let us know. And I know that you've just been through a traumatic incident in terms of your health condition. The first thing that I wanted to know about was the statement in the preliminary hearing to the effect of when you were asked how much blood did you withdraw from Mr. Simpson, where you said approximately 8 cc's.
Yeah, that was an estimation, because that's what we all think we draw at that time.
When you say we, you mean?
The nurses.
And when you say that you think that you usually draw 8 cc's, that's based upon what?
Based upon what the vat container tube pulls out of the yarn.
Do you regularly measure how much you've drawn from a person after you've drawn the blood?
No.
Have you ever done it on any previous occasion prior to when Mr. Simpson came in?
Oh, I draw blood quite often, but not this sort.
But you don't measure it?
No, we never measure any blood.
Okay. And when you said not the sort, what do you mean by that?
Well, usually I draw blood for people that are arrested on blood.
Okay.
And that's usually different treatment and different method. We just draw it and that's give the officer and that's it.
So was there something about this statement that I just mentioned to you where you were asked this question, how much blood did you withdraw from Mr. Simpson? You said approximately 8 cc's. And then you went on and you were asked, when you say approximately, did you not measure the amount? You said, well, it could have been 7.9 or it could have been 8.1. At some point, did you realize that that wasn't correct?
Not that day.
Okay. How did that come about?
I heard from a friend of mine who heard on television that there were approximately 2 cc's of blood missing. So I took it on my own to find out, well, did I really draw 8 cc's or not? So I took an empty vial.
Okay. So before we get into that, when approximately in time was this? Do you know when it was?
It's so long out, I would say about a week, maybe 2 weeks later. Now, I can't swear to this, but it was at some time when it was mentioned on television that there were a couple of cc's missing. At that time, it was the next day.
Well, was this around when the trial was in progress?
Yes, I believe it was during the trial.
Okay. Do you know when it was in relationship to Mr. Cochran's opening statements? Okay, so were you watching the trial?
No, I just got a phone call.
Okay, but whenever this was, it was when the trial was going on. Okay, and you got this call from your friend, and then what did you do?
Well, I don't think you want to hear on television what I said, but the next day I went to work and I started pulling out test tubes, and I pulled out a syringe, and I got some water, and I started measuring 1 cc and put it in the test tube, and I kept doing it until I got 8 cc's. When I saw how much 8 cc's was in the test tube, that was more than I drew. So I took another test tube and kept putting in water until it looked approximately as to what I had drawn. I measured that, and that was about 6.5 cc's. So I estimate that that's what I really had drawn.
Okay, and can you repeat for us now, using some of the things that you have here with you, this procedure that you went through in order to figure out that it wasn't the 8 cc's?
Well, I can empty out one of these test tubes and...
Okay.
Sure. I need more, so basically throw some.
Oh, okay, let's take a break while he wants to throw that water away.
Now, when I did this experiment myself, I used a 1 cc syringe, which I don't have here. So we're going to have to go on the 10 cc's, and this is a 10 cc syringe. This is definitely not the way to take off a needle. Okay, the way I did it, I drew 1 cc at a time. Here's 1 cc. Okay, there we have 1 cc. And at that point, I put little lines, a piece of paper with little lines, and marked 1 cc. Okay then. Two cc's.
Sure. Yeah, just repeat what you did.
3 cc's. This isn't the ideal place to be doing this.
Okay, what were we on? 2 cc's or 3 cc's?
4 cc's.
Careful sticking a needle back in your cup.
Oh, this needle isn't being contaminated.
I just don't want to be stuck.
Well,
Good shot.
this is 6 cc's here. Seven. That's approximately 8 cc's right there. That was more than I drew,
And how did you know that?
because it looks like it was more than I drew. So what I drew was approximately down to this point. If we take that out, we'll know about what it was. So I did take out 6 and a half. About 6 and a half. There you go. Which should be 6 and a half cc's. Should we make it
And sure.
approximately 6 and a half? And there we go. Approximately 6 cc's and a half.
So, after you had done this, what conclusion did you come to?
I came to the conclusion I was wrong in the statement I made, that I didn't draw 8 cc's, that I drew about 6 to 6 and a half.
Is that an approximation?
That's still an approximation.
Yeah. Now, incidentally, you said that you talked to this friend. Was this someone who was watching the trial, or?
Oh, he wasn't watching the trial. He got a phone call from another friend of mine who was watching the trial, who called him and said, "Hey, Paratus goofed up." And this was something that they harassed Paratus on. And so Paratus decided to straighten it out right away. That was, but he, per se, was not watching it. He just got the call, and then he called me.
Okay. And then after you had straightened this out in the way that you just described for us or demonstrated for us, did you then call the DA's office to tell us what happened, or to try to tell us what happened?
Yes.
And then I spoke to you.
And you spoke to me the day you brought me the subpoena. And that's the day I told you.
Did I have a copy of that?
That was around
February 3rd?
February 7th is when he gave the subpoena.
Oh, it's 4th February 7th. But at any rate, it was in February. First week of February.
And so it was that day that, because I had called you, and in the meantime, I had heard from Patty Joe that you wanted to talk to me. So I asked you to come down to the dispensary.
Okay. And did you go through the same demonstration that you just showed for the camera today when I was at the dispensary? Can't remember. That's all right. Now, there was another statement that I wanted to to ask you about that also took place at the preliminary hearing. Let me just get hold of that. And that was the statement that said, I just looked at the syringe and it looked at about 8 cc's.
That was a
Remember
student
that?
statement, which I didn't make. I looked at it, I should have said, it looked like it was enough, which it was enough. 8 cc's, I was wrong in that 8 cc's altogether.
Can you show us what you did do in terms of looking at the syringe after the blood, or when the blood was being drawn? Mr. Simpson?
Here, okay, the blood was pulled out. I pulled it out, I saw that, what it was, I squirted the blood in tube in. Trash. I just looked at the syringe.
Okay,
I didn't turn it over.
there is a part of the syringe that was
Oh,
calibrated.
yeah, but I didn't, we just, unless you have a reason to look at those calibrations for dosage purposes, well, you just don't do it. Please, I don't know how many nurses do. I've asked nurses, hey, do you know exactly how much blood you've drawn? No, about 8 cc's. Now, you want to make a bet and we'll check next time? Nobody wants to take the bet, take me on that bet.
So where did the figure of the 7.9, it could have been 7.9 or it could have been 8.1 come from?
It was an approximation. Even what I did here, okay, 6.5, but it could be 6.4, it could be 6.6. You can't, this is not exact. None of this stuff is exact. If you have it ordered exactly, then you're very careful. We don't have any special orders of how much you draw. If somebody should request a certain amount of blood, then I would be extremely careful to draw that much. So far, I've never had a request like that.
Okay. I think if there's anything else I want to know. You indicated something to the effect that when you had this telephone conversation, you made some comment to your friend that it was using language that wouldn't be polite to repeat. Were you upset at that time when you learned that someone was
No, it's usually when you goof up, what's the first 4 letter word you say?
Okay.
Oh, okay, so that.
All right, I guess. Sure.
No, I really, well, I was upset, I was just kind of upset with myself that I made the goof up. And I realized that I had made an error then, which might create problems, and I wanted to rectify it as soon as I could.
Do you usually take blood with a syringe, a hypodermic syringe like the one that...
Most of the time we use, I myself, most of the time I use the vacuum. But when I get someone as big as OJ, big arms, big muscles, I myself have found I can control it better when I use a syringe. It's like, you just go in, just try to sit and be able to keep my finger on that vein and go bang without a problem. Other times, I can do a lot better just by using the other, you for example, without a tourniquet, I could just go bing on you.
Yeah, that's what I do. Now, when you say that you usually use the vacutainer, what's that?
The vacutainer is, this is the vacutainer.
Oh, okay.
And what you do, you put a, I don't have one of those now, but you put a, it has a needle on this end too. You screw it in here. Then you put this in here, and you inject into the, and then when you're in the vein, you push on this, and it just sucks it blood through.
And that's based on the vacuum that's in the tube?
See, on this now, nothing would happen, because if there were any error in there, we just suck it out, that's all. But this is made for a different type of thing. They usually have a needle on the other end. Just inject the needle.
How often do you use a syringe as opposed to a vacutainer?
Oh, not very often. It's just when I get a big person. And like I make an evaluation of the arm, and that's, you get in the habit to evaluate. You look at the other, I look at him, I have no trouble. If he came in for anything, I'd immediately go for a vein like that. I saw his arms, and they had veins like that. Oh, these never hurt here. And I just go like a big bang at it. With anything on him, because those are nice big veins. I used to have those until I had them ruined on this side. But when you get some of that, OJ is big. I've had other big people like that. I usually just find it's a little easier, not only for me, but for the patient. You don't have to dig around. You just hit them, and that's it. And I haven't had any complaints of an ouch or anything.
Did you have any problems when you were drawing blood from the defendant?
No. I just, at this one certain point, as I was pulling, the bevel of the needle hit the wall of the vein, and that's when it stopped. And so you either turn your syringe and draw more. But at this point, it appeared like I got enough. So that was it. I just stopped it.
Is that when you looked at the syringe at that point where the needle hit the wall?
Well, I was surprised the needle hit the wall. It's the only reason it stopped.
Oh.
It was the reason the blood would stop. And I figured, well, that's enough. In fact, every time I draw blood and I reach that point, it's just, well, you've got enough blood. There's no point in going any further. You can turn your needle and continue drawing, but there's a slightest, in my opinion, there's a slightest chance that you may damage the wall. I don't want to take that chance.
But when in relationship to the blood stopping, was it that you looked at the syringe? Oh, that was when it was?
Mm-hmm.
But you looked at the part that's opposite from
Yeah, the calibrations were on the bottom.
Okay. All right.
Because again, that's not what we go by.
You're going by what?
No, we just go, it seems like you go by instinct. But I've never had a case where we've never had no blood.
You know, where they came back and said you had drawn blood?
Yeah, I've never had a case where we need more. I don't know of any case, and if there has been, I don't know any, in our department, I don't know anything about it.
Okay. I think that's about it, unless you have something else you want to speak. All right. Well, thanks a lot.
Well, you sure will.
I'll hear from the proponent.
Well, Your Honor, there's not really a whole lot to say. I thought that we'd already argued this once before, and the court had indicated that we could use inconsistent statements from the witness, and under 1202, we are entitled to use inconsistent statements from a hearsay declarant, and that's what this is. It is inconsistent with his testimony that he withdrew between 7.9 and 8.1 cc's of blood, and it is also inconsistent with the inference that was contained in his testimony that he looked at the syringe, although it was a little bit unclear from the testimony that was written to the record. He did seem, the inference that the defense wanted to be drawn from it is that he looked at the syringe, and that's how he knew exactly how much was drawn.
Your Honor, this issue has never been argued before. In fact, it was deliberately postponed for this particular purpose because you decided that the appropriate time to raise it would be during the course of the people's rebuttal case. And we could all sit here, we could stand here, and we could laugh at some of the jokes made on that tape. And I agree, at times it seems pretty funny. And if it wasn't for the fact that Mr. Simpson was on trial for his life, I would sit here and laugh at it. But if the prosecution actually thinks that they can offer a tape like that, full of rank, staged hearsay, completely concocted solely for the purpose of this litigation, after they knew we were going to introduce the grand jury testimony and the preliminary hearing testimony of this witness, then what they have done is set back notions of due process maybe 50 years, taken the Sixth Amendment and stood it on its head, and suggest for a moment that they can somehow take a notion of unavailability and use that as some kind of license to put any kind of charade forward to this jury. It is absolutely absurd. All the court has to do initially, Your Honor, is to start thinking back about the history of Thano Paradas. And what we have with Mr. Paradas is someone who, as you may recall, the defense urged the prosecution to call as part of their case because we thought it was an indispensable witness to lay a foundation for the introduction of Mr. Simpson's blood vial. They refused. However, one of the things that I learned on this tape for the very first time is that they had subpoenaed Mr. Paradas to testify on their direct case, but at some point obviously changed their mind. So at that point in time, Mr. Paradas was healthy, was available, could have testified, and we did everything to urge his live testimony before this jury, where he would have been subjected to this type of examination and cross-examination that most witnesses are subjected to in an adversary system. In any event, they didn't do it. Sometime in late June or early July, Mr. Paradas had a massive heart attack, and as we learned in court, went through a quintuple bypass, and apparently it was his third bypass surgery in his adult life. As a result of that, he was then deemed unavailable. Now, when it was determined he was unavailable, we at that point informed the court that we intended to introduce his grand jury testimony where he was called as a prosecution witness, his preliminary hearing testimony where he was called as a prosecution witness, and that was going to be our offer based on the unavailability. And we're entitled to do that not simply based on the California Code of Evidence. We're entitled to do that based on the United States Constitution and a series of cases which have defined appropriate remedies when there's an unavailable witness. And that's what we did. One of the things that's really interesting, Your Honor, in Mr. Goldberg's statements is that on July 27th, the morning before this outing occurred at Mr. Paradis' house, and this prep session occurred, and these questions and answers ensued, is that Mr. Goldberg came into this court and said on the record at page 39085 that what he wanted to introduce were prior inconsistent statements of Thano Paradis. That's what he said. I can actually, the exact words are that if Paradis came into this courtroom during and testified, we would of course be allowed to introduce, to impeach him, prior inconsistent statements. Well, we should be entitled to do the same thing if he's not here, if he's unavailable. That was the representation Mr. Goldberg made the morning of July 27th. Well, he didn't have this tape the morning of July 27th. He went out at apparently 3:30 in the afternoon and collected these statements during this rehearsed interview with the witness, Thano Paradis. They're not prior inconsistent statements. The statements that we introduced by Thano Paradis were made back in June and I believe early July of 1994. That's the historical background to what happened here. We submit, Your Honor, that there are three separate reasons why this kind of rank hearsay is inadmissible at this point in time in these proceedings. First of all, Your Honor, although 1202 says that hearsay can be introduced to impeach a hearsay declarant, it does not cover all circumstances. It is not something which overrides the U.S. Constitution, nor did the legislature intend it to. In fact, in Section 1204, 2 sections later, in the same evidence code, it says unambiguously that a statement that is otherwise admissible as hearsay evidence is inadmissible against the defendant in a criminal action if the statement was made either by the defendant or by another under such circumstances that that it is inadmissible against the defendant under the Constitution of the United States or the state of California. So clearly the legislature was aware of the fact that not all hearsay is going to come in under all circumstances. And if in a criminal case the statement is to be used against a defendant, which Mr. Simpson is obviously in these proceedings, then it has to be done in a way that's constitutional. And there's something in the Constitution called the Sixth Amendment, which gives the defendant the right to confront witnesses who wish to give testimony against him. And the Sixth Amendment, Your Honor, has been construed most recently on this particular issue in 1980 in the case of Ohio versus Roberts, which can be found at 448 U.S. 56, 1980. And in it, what Roberts says is that there are two requirements that have to be met before something like this can occur. Number one, there has to be a finding of unavailability. I can only assume that he was unavailable, although he didn't look that ill in the course of this videotape on July 27th. But let's assume for the purpose of this discussion that they can demonstrate unavailability, as we asked for unavailability 2 months ago in these proceedings. What Roberts says is that that's not enough. What you then have to find and make a finding of is there is sufficient indicia when you do some kind of balancing test that these statements are trustworthy for their truthfulness. That's the finding that the court has to make before you can find an exception to the hearsay rule that would pass constitutional muster under the Sixth Amendment right of confrontation. And I would suggest to the court, Your Honor, that in this particular case, they don't come close to meeting any of those indicia. Number one, what he's saying here on this tape is that his unsworn testimony on this tape is that his sworn testimony was false, and that it was false in two very substantive, important regards. Number one, he's saying his sworn testimony was false because he said that he had drawn 8 cc's. Now he's saying he hadn't done that. And two, he's saying it was false when he testified a year ago that he had, by looking at the syringe, you know how much blood you draw. What's extraordinary and completely unbelievable in this statement made a year later is a suggestion that notwithstanding the fact that the syringe is calibrated, and it does have numbers on it, and it does have lines on it, that he never turned it around to the side that had the lines on it and the numbers on it. Although that is in marked contrast. In fact, it contradicts the sworn testimony he gave before another court at a preliminary hearing. So that's one indicia of reliability that is absent in this particular statement. A second indicia of reliability, Your Honor, is that there is no defense attorney present to participate or sit in on this particular interview that occurred on July 27th. There isn't even an independent party. There is an advocate. There is the prosecutor. There is Mr. Goldberg. And I would point out at this point, Your Honor, that Mr. Goldberg is participating on this videotape as an unsworn witness. This is not testimony in a courtroom where a lawyer gets up and is cloaked and certain privileges being an attorney. This is Mr. Goldberg, the private citizen, out there with an unsworn witness, and he's unsworn, asking certain questions, making statements about what this witness may have said to him off camera or on other occasions, and then getting the witness to confirm or affirm those statements. He, too, at that point, is an unsworn witness. So there's no defense attorney present. There's no independent person present to assess the reliability of this staged reading that we just saw. The statement is not made under oath. And in fact, the statement is made after, not as a prior inconsistent statement. The statement is made the statement is made a year after he testified under oath. The statement is made 6 months after the trial begins. The statement is made 3 weeks after we tell the court that we intend to introduce the preliminary hearing testimony and grand jury testimony of this witness. What better motive is there to fabricate at that point? Now, the other issue that's often relied upon by courts in this context is that, was the statement made, was it some kind of innocent hearsay? Was it a situation where this witness, Mr. Parada, simply said to a friend, X, God, I made a mistake about something, or something like that? Is it that kind of statement? As opposed to a statement that is made explicitly and exclusively for the purpose of litigation. There is no question at all that this statement was made for the purpose of litigation. And when statements are made purely for the purpose of litigation, Your Honor, that indicia of reliability is lost. And it's very difficult to compensate for it. Certainly it's not compensated for in the facts of this case. Now, what's another indication? Well, does it sound right? They have the temerity to suggest that this man, who is drawing blood on a regular basis, a year later, remembers when he looked at a blood vial on June 13th of 1994 how full it was. When he said that he prepares blood vials on a routine, regular basis all the time, be it in drunk driver cases or any other kind of case, he does it routinely. And he is suggesting that all of a sudden now, a year later, he can remember how much blood was in that particular vial as opposed to the other vials that he drew. Yeah. It's extraordinary.
It's not often O.J. Simpson comes in and asks you to take a blood sample, though.
Well, if it's exactly, and that's why when he testifies under oath at a preliminary hearing in the grand jury, Your Honor, that there's 8 cc's of blood, and it could have been 7.9 or it could have been 8.1, and I looked at the syringe, and that's what the syringe says, that's exactly why he knew it then. And that's exactly why the Constitution prevents the prosecution from coming in later on and going out to a man's house after he's declared unavailable and putting on a charade like this, where there's no defense attorney present, where it's unsworn, it's not even a deposition, and he can say anything he wants, and it can never be challenged. That's not what 1202 had in mind, and that's why the Constitution gives you those protections, Your Honor. Now, I'd also point out, one moment. In that regard, Your Honor, I would also point out that there is no independent basis for admitting the statement, because even though the statute 1202 envisions that hearsay will be admissible, there still has to be some basis for it. This is not a prior inconsistent statement. This doesn't meet any of the other criteria for ordinarily impeaching this kind of witness who was offered sworn testimony. And the sworn testimony that was offered here was sworn to back in June and July of 1994, not July 27th or 28th of 1995. That's when it would have to be prior to that, Your Honor, because that's when he made the statement. In terms of a motive to fabricate, he said it was when I heard during the trial that there was 2 cc's, although I think the testimony was really that it was 1.5 cc's that the vial was short, that I thought I may have screwed up the prosecution's case and decided I had to look into this. Now, if that's an issue of reliability, that's extraordinary. It would be stretching all the rules of evidence, Your Honor, to allow something like that to pass muster legally or constitutionally before this court. Finally, Your Honor, the tape in and of itself, apart from violating the Constitution, apart from not falling within the confines of 1202, its content itself would render it inadmissible under any kind of 352 consideration or the court's own inquiry as to whether or not this would be a fair and just thing to do. And remember, Your Honor, that's what you have to come back to. Is it fair and just to allow this kind of staged Q&A by Mr. Goldberg to come in to rebut their own witnesses' sworn testimony that he gave on 2 prior occasions? And in that regard, you have this individual on the tape describing double and triple hearsay. Says that I didn't even see this statement on television. I heard it from a friend who heard it from a friend. And, Your Honor, I can offer testimony right now from Robert Blazier or from Joellen Demetrius, who were both with me at the infirmary interviewing Thano Paratus on April 11th, 1995, about this issue. And we walked into Mr. Paratus' office. He had in the infirmary a television, and the television was on. And we asked him why he has a television in the infirmary where he works. And he says he has the television in there so he can watch the O.J. Simpson trial each day, because it's often slow in the infirmary, and there's nothing to do. We asked him then, did anybody in the prosecutor's office tell you that you're not supposed to be watching this? And he said, no, no one ever told me that. Maybe that's the reason why he came up with a new explanation on this videotape on July 27th. But I can offer sworn testimony from Joellen Demetrius or from Robert Blazier on that particular point. And what he said was, and this is what triggered it all in his mind, is he was listening to Mr. Cochran's opening statement when he heard about the 1.5 cc's. And he became alarmed that perhaps he was going to hurt the prosecution's case. And at that point in time, for the very first time, he began to reconsider this whole thing. Now, on the one hand, he's admitting to us that he's watching this trial every day, has a TV in the infirmary, and then all of a sudden he completely changes the basis for how this information came to his attention to cover his own behind for being caught watching this show every single day. I'm telling you, Your Honor, this is not somebody who you can trust under those circumstances when we don't have a sworn witness here. Number two, Your Honor, he's describing in the course of this Q&A an experiment he conducted. And that brings us back, Your Honor, to something that came up.
He doesn't describe it, he replicates it.
Well, he does. That's the point, is does he substantially replicate it? In fact, he even says, listen to this, it's an experiment within an experiment. Because what he says is, I'm doing it now one way. This is not the way I did it. In fact, when I did it in my own infirmary after hearing Mr. Cochran's opening statement or hearing the reference to the missing 1.5 cc's. So you don't have substantial replication, number one, on the video of an experiment that he did in his own infirmary. Neither experiment substantially replicates the manner in which he drew blood from Mr. Simpson on June 13th. So none of those experiments or description of them would meet the case law criteria that they have asked for in keeping out other experiments that our witnesses have tried to introduce. This certainly falls way short of the glove drying experiment that Mr. Scheck tried to introduce that had been performed by Henry Lee. It doesn't come, he even says so. So if the content...
Swatch drying.
I'm sorry, the swatch drying experiment. The swatch drying experiment. What did I say, glove? It's a day of gloves, Your Honor. So just to recap very briefly, Your Honor, it doesn't meet the Constitution.
No, we don't need to recap.
Okay. Your Honor, I'm just saying that there are so many reasons why this can't be permitted at this point. It's almost as if we could have just turned off the tape and not had to have any argument at all. It's that shocking, frankly, to even to think that the prosecution would believe that his asking hearsay questions to a witness under those circumstances, based on what's happened in this case, could possibly be screened before this jury.
Thank you. May I respond? First of all, I don't understand why this type of hysteria and advocacy is necessary, especially when we're dealing with a very straightforward evidentiary issue and the types of aspersions that counsel likes to cast. I don't know what he's talking about when he says this was staged. You may not appreciate, once again, my directorial abilities, but clearly this is not staged or rehearsed in any way, mean, shape, or form. Not that is necessarily what's relevant here legally. When we discussed this the last time, if paraphrasing the court's comments correctly, and I believe I am, I think what the court said when counsel expressed amazement at the idea that we could get inconsistent statements of a hearsay declarant is the court said, well, it's something that we have in the state of California called the evidence code. So we did discuss it before. I don't know whether the court formally ruled, but I think the court has a very clear understanding of this issue and what the laws in the state of California. Now, what is admissible under 1202? It is not prior inconsistent statements that are admissible under 1202, the credibility of the hearsay declarant. It is evidence of a statement or other conduct by a declarant that is inconsistent with a statement by such declarant, period. It doesn't say anything about prior inconsistent statements. This is the kind of shorthand that we attorneys often use that gets us into trouble because we're used to saying prior inconsistent statements, and in actuality, the code does not speak to prior inconsistent statements. It talks about inconsistent statements. Evidence Code Section 1235 says that evidence of a statement made by a witness is not inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing. Again, it doesn't say prior inconsistent statements. And the commentaries to these sections make it absolutely clear that there is absolutely no requirement, and never has been one, in this state or any other state, that the statement has to be a prior inconsistent statement, merely that it must be inconsistent. And this is inconsistent. The next thing that I'd like to point out is that counsel makes a constitutional argument that is entirely misplaced and stems from his misunderstanding of California evidence law. The section that we are relying on, 1202, is not contained in the hearsay exceptions section. It's contained in Chapter 1. Hearsay exceptions start in Chapter 2. Why is it that the legislature put this in Chapter 1? Because it is not an exception to the hearsay rule. And in fact, and perhaps I should not point this out to counsel because he apparently doesn't know this, the defense...
Well, counsel, now we're getting into the same kind of conduct that you were...
Well, I'm just criticizing his legal analysis. I'm not criticizing any other aspect of what he said. They would be entitled to a limiting instruction that this is coming in only for the purposes of analyzing the credibility of Mr. Paratus. It is not coming in for the truth of the matter asserted under this section. It is coming in for the purposes of showing that someone who has made an inconsistent statement on the points to which he previously testified cannot be trusted with respect to those statements. So there are no trustworthy requirements. It is not being offered for the purposes of proving that those statements... I thought maybe Mr. Cochran wanted to add something. It is not being offered for the purposes of showing that those statements are true. It is being offered for the purposes of showing that his prior sworn statement is not reliable. And that's why you do not need to satisfy any other requirements of trustworthiness or anything other than what is provided in the code itself. This is a very simple problem of mechanically applying the evidence law that is very well established. There is no issue. There's no 352 issue. If counsel wants to introduce other inconsistent statements of Mr. Paratus, maybe he can, maybe he can't. I think we should take those up when it is appropriate. And if the court were going to rely on any conversations that he has, those should be reduced to a declaration rather than relying on his representations, because he has not correctly stated even what Mr. Paratus's former testimony was, because he did not say he looked at the calibrations on the syringe. He said he looked at the syringe, and no one ever asked him whether he looked at the calibrations or not, although that is one possible inference. So I don't think that we can necessarily represent at face value counsel's paraphrasing his conversation with Mr. Paratus. And it's not relevant anyway. It's just not, it's beside the point as to this issue. Now, as to the question of the so-called experiment, this is not an experiment that is being offered for the purposes of illustrating what actually happened. This, again, not coming in for the truth of the matter asserted. This is simply explaining how Mr. Paratus came to the conclusion that his former statements were incorrect. If Mr. Paratus testified that he looked up in the sky and saw clouds in the shape of a 6.5, and that's how he came to the conclusion that he really drew 6.5 cc's, that would be admissible too. We don't have to prove that looking in the clouds is a reliable way of figuring it out. All we're trying to show is that he's made an inconsistent statement, and that is part of his inconsistent statement, and why he believes that his previous testimony was not correct. So it is not coming in as an experiment, but simply as part of his inconsistent statement and some explanation for how he came to the conclusion that what he previously said was incorrect. So all we are asking the court to do is follow the evidence code. It's very clear. This is an inconsistent statement. Comes in. I think we were the moving part.
That's correct. All right, counsel, you've argued to the court Ohio versus Roberts, which is Justice Blackmun's opinion from 1979 that I don't recollect, frankly. It was just handed to me. I'd like to read it. So we'll take a couple moments and I'll rule. I want to read this before I rule, since you cited it to me. And I have not read this recently. I don't recollect the facts or circumstances of this case. But let me just make an observation, Mr. Goldberg. There's a lot of stuff in that tape that is not specifically a statement inconsistent with Mr. Paratus' testimony at the preliminary hearing before the grand jury, and there's a lot of surplusage there. Also, I think the court's rulings regarding demonstrations and experiments are pretty clear and pretty consistent. So, perhaps, I mean, do you have an edited version of this tape available, where solely the statement as to what he drew?
No, Your Honor, because it would be difficult to ferret out exactly what portions those are, because in every portion, almost every portion, it seems to me he is explaining why it is that what he said was incorrect and how he determined it to be incorrect. There may be certain instances where I could see the court saying that those statements do not do that directly or indirectly, but otherwise it seems to me that everything else is either directly or indirectly inconsistent with his testimony in the prior hearings.
All right. Well, I'll read Roberts and I'll rule. All right, we'll take 15.
Also, for the record, counsel did not cite to me Roberts in advance. I'd read it before, but I did not have the opportunity to reread it for this hearing.
No, it's been a long time since I've read it. All right, take 15. Had the opportunity to read the State of Ohio versus Herschel Roberts, 448 U.S. at 56. Court's ruling is as follows as to the admission or non-admission of the statement by Mr. Paratus. record reflects that the court previously made a finding of unavailability of Mr. Paradas as to be on the basis of his medical condition, that medical condition having been prior heart bypass surgeries and now a quadruple bypass surgery. I believe this was his third bypass surgery. His doctor had indicated that he was not available to testify in court, and neither side has chosen to challenge that finding at this time. The prosecution offer is that of a statement as evidence of impeachment of a hearsay declarant under Evidence Code Section 1202. This is not an offer under 1235, an offer of a prior inconsistent statement or of an inconsistent statement. For the truth of the matter stated is merely for impeachment purposes. It is therefore limited in its use. The cite to the Roberts case is not applicable to this particular fact situation. The court has found previously unavailability of this particular witness. The court allowed the defense to then present prior testimony, both before the grand jury under oath and before the magistrate at the preliminary hearing. And under any circumstance, a statement made by a witness which is inconsistent with their, not under any circumstances, but under most normal circumstances, an inconsistent statement would be admissible for the purposes of impeachment. The troubling part of the proffer is that this videotape contains the demonstration of an inadmissible experiment and contains extraneous double and triple hearsay information given to Mr. Paradas by other persons. The court will sustain the objection to the experiment part of the tape. Anything that is irrelevant or extraneous, the people may offer an edited version of the videotape where Mr. Paradas specifically discusses his testimony regarding the amount in the syringe. However, the remainder is excluded as being superfluous, and the court will see the videotape in its final form before it's exhibited to the jury. All right, that's the order. All right, any other issue we can take up before we recess for the day? Yes, Your Honor. Mr. Shapiro.
All right. Important matter, the letter memorandum and request for relief concerning the testing of Mr. Goldman's blue jeans and the state of discovery with respect to the testimony of, proposed testimony of Mr. Diedrich, I have to bring to the court's attention.
All right, we have Mr. Goldberg present at this point in time.
Yes. Now, Your Honor, yesterday they turned over what appears to be a report from Mr. Diedrich, wherein he indicates that he is going to testify based on experiments that he's already done, that the imprints on the blue jeans of Mr. Goldman came from Mr. Goldman's shirt, and the imprints on the letter and the piece of paper came from Mr. Goldman's blue jeans. Okay? Now, the prosecution turned over to us a few photographs and statements about how on August 21st, the day before Dr. Lee testified, this is very curious because Mr. Goldberg was saying it all came as a big surprise to them, but on August 21st, they went and did test impressions, too, of Mr. Goldman's jeans. And the way the test impressions were performed is apparently using something they call an identicator, but from the pictures it appears to be something that they ordinarily use to roll palm prints. And they would press this yellow, what they call in the reports, a yellow piece of paper onto the jeans, and then they would roll it with a roller. Then they place a white piece of paper on top of that, and then they roll that over the jeans, and then they get some kind of what they're calling impression. They apparently did 2 of those on August 21st. We have a small picture of one of those, but nothing that we can show an expert that they can do anything with, and we have no idea whether this is what Mr. Diedrich's using. Then, on August 31st, they took 5 more impressions of the jeans, and they took impressions from Mr. Goldman's shirt, and they took impressions from the shoes. The shoes have been ruled out. Apparently, all these documents were then sent to Mr. Diedrich in Washington, where he made an analysis and came up with a report. This was done without notice to the defense. Now, what I can show the court, and the pictures, they have P numbers of 4971 and 4967. And I would like to mark these as exhibits, if I could. Why don't we deem them defendants next in order A and B.
All right.
And what the court can see, and these are apparently the impressions that were done.
1374.
1374. 1374A and 1374B. 1374A shows
to Mrs. Robertson.
shows the piece of paper that presumably has an impression on it. And 1374B shows the genes before this process was done. Now, we haven't seen the genes since they went through this process, but I know from their own reports that they did 5 more impressions on the genes since then. And what you see there is the results of only the first 2 impressions. And I think the court can see that on the genes itself, there is a triangular impression that must come from the other side of the genes being impressed onto the front side of the genes. In other words, you can see an imprint pattern or a pattern on the genes after they went through this process that wasn't on the genes beforehand. Now, that is a matter of serious concern under Griffin and Arizona versus Youngblood. The reason it's a matter of serious concern is Dr. Lee testified to the imprint patterns on the genes. And those imprint patterns, I dare say, were favorable evidence to the defense. That's clear. It's the subject of their rebuttal. This court had already issued an order that we're supposed to be given 48 hours notice if the prosecution is going to conduct any potentially destructive tests so that we can have an opportunity for an expert to be there and also to litigate the reasonable necessity of doing that evidence. It seems absolutely clear to any sensible person that the process of taking this test impression as they went about it would create a risk of altering the genes. What's worse is that it's plain from the photographs of August 21st that they altered the genes with the first 2 test impressions they took. And we haven't seen the genes since, and there are no pictures of them that I see here, but they did apparently 5 more test impressions. Of course, they've done the same things to the shirt. So it seems to me that there is an issue here that we will have to litigate with respect to a bad faith alteration of exculpatory evidence. I mean, this is a classic because there was an outstanding order. It could be anybody could see, even particularly after the August 21st impressions, that they were going to alter the evidence. So there's really no good faith justification for doing this in secret. And anyway, they were under orders to do it, and any responsible prosecutor would have given us notice. And in fact, quite the opposite was going on. We were sitting here with Mr. Hodgman and Mr. Yokelson looking for Mr. Goldberg to get various data from him about contact sheets and something else, and there were 1054 proffers to the court. I don't know what they were about what they were going to do, but they shouldn't have been doing this in the fashion they did without giving us notice. We cannot fully litigate how much these genes were altered or the other items. We haven't seen them yet. I don't have experts available to look at them yet, particularly since we don't have the underlying data that apparently is going to form the basis of Mr. Diedrich's testimony. That is, we don't have the actual test impressions. Now, I asked Mr. Goldberg yesterday when we were going to get this data and when we were going to have an opportunity to look at the genes, take a look at their test impressions, compare it with one expert, so we can make copies of the test impressions, see which ones or which part of this pattern Mr. Diedrich is claiming matches something on the envelope, the piece of paper, or how something from the shirt matches the genes. And we have to see what he's actually done. And I asked him what was going on and would they give us notice if they were going to do something else. He told me, well, he takes the position that nothing gets altered, it's not a destructive test, and that Mr. Diedrich is going to arrive here sometime tomorrow afternoon, and for the purposes of only having one witness testify, he's already finished the report, for only having one witness testify rather than bring in these people from the LAPD who actually rolled the impressions, he was going to have Mr. Diedrich do more test impressions. So only one witness would have to testify, and they wouldn't have to bring these other people in. And I asked him, well, are you going to give us notice and a reasonable opportunity to bring an expert there to even observe this and to litigate the issue of whether you can go about and do yet another set of test impressions even after he's finished his report and alter the evidence some more? And he said, well, I'll tell you when he's coming, but we won't wait for you. Now, I've done my best to try to get somebody here who's knowledgeable in the area. I've spoken to Mr. Morton. He can be here on Thursday if Mr. Diedrich is going to come and bring his materials. But we want to just basically have an opportunity to look at the genes, review with Mr. Diedrich the test impression sheets that he has, see exactly what the basis of these experiments are. Have Mr. Morton review it, make copies of it, send it to Dr. Lee and Professor McDonald so that we can have an evaluation of it. And I can tell you this, we won't be ready to either litigate the issue, the Arizona versus Youngblood issue, or another extraordinarily substantial issue I see, and that is, I don't think there's a sound basis, just from what I've seen so far, to get these experiments into evidence under the substantial similarity test and the way the court has been ruling on these experiments. It's a very serious issue. I can't even adequately litigate that until I see the underlying data from these reports. So I'm, really quite flabbergasted that Ms. Clark, who apparently is going to put on these witnesses, can stand up here and say, well, we're going to rest on Thursday. We're calling Mr. Diedrich in the next 2 days. When they're not even making an effort to give us discovery, and worse than that, they're spoiling the evidence. Hey, this is a railroad. This has to stop. Because this is completely inconsistent with the discovery law in this state. It's inconsistent with positions they've taken. It's ridiculous. So the relief that we're asking for, and I think it's one that's reasonably designed to try to get this trial over with in a fashion that's fair, is that we can bring Mr. Morton down and he can look at this data. We can evaluate it. We can file our motions with respect to any alteration. There is no need for them to take yet another test impression just so Mr. Diedrich alone can testify, because that is on its face gratuitous. He's already filed his report based on the data that he has. And we need an opportunity to evaluate the evidence, to make our Griffin motion with respect to that evidence, whatever prejudice has ensued, and also to file a fully informed motion with the court objecting to those experiments, because I can see right now that there are serious problems there and something I'm sure the court's going to want to look into. If we're given that opportunity to get the data on Thursday, I can send it Federal Express to Dr. Lee and Professor McDonald. We can evaluate it over the weekend. We'll file the papers on Monday. The court can consider it. After rulings, we'll see whether or not Mr. Diedrich can testify, and we can proceed from there. That's my proposal, to do this expeditiously. And we want, as indicated in my letter memorandum, we want the relief of having the discovery that we're entitled to by tomorrow, or certainly by Thursday, I should say, an opportunity, an expert to look at the shirt, the pants, et cetera, and what Mr. Diedrich's done, and then an opportunity to have our experts look at it before they do anything else to this evidence, so we can proceed in an expeditious manner.
People?
This is remarkable, Your Honor. I don't know whether the court's had an opportunity to read our motion yet for discovery sanctions relating to Dr. Lee. I hope the court perhaps will take a look at that before dealing with this issue if Your Honor feels you have to take this under submission, if you feel that you cannot summarily dispose of it right now. I learned for the first time on or about August the 21st, when I spoke to Dr. Lee, that somehow he had excluded the genes as having made the impressions in this case. I did not learn that as a result of defense discovery. It was not documented in any report. I learned it as a result of my conversations with Dr. Lee. He was cooperative with me. I learned for the very first time on this witness stand that he also excluded the shirt. That was not documented. That was not in any defense discovery. And now they are claiming that somehow we have violated our discovery obligations and our legal obligations because upon learning of these violations and of this evidence, we expeditiously went about being able to confront it and present a rebuttal case as quickly as we can. I do find that to be remarkable. Now, Your Honor, just so the record is clear on some of these factual points, on August the 21st, or on or about August the 21st, this was around the time that I learned from Dr. Lee, I believe, his statement about the genes, I caused an impression to be made pursuant to the instructions of Mr. Bodziak, who I also consulted, in order to be able to cross-examine Mr. Lee on this point. I was working very rapidly. I didn't have any real notice on this issue by the defense. I wanted to know in my own mind before cross-examining Dr. Lee whether or not the genes could have been involved and possibly had that impression to be used as an exhibit for cross-examination. I tentatively planned on using it, but elected not to during cross-examination. I felt that it was tactically not necessary. On the 31st, after learning that Dr. Lee had also excluded the shirt, I wanted impressions to be made of an examination quality of both items immediately so that that material could immediately be sent to the FBI so that we could rapidly perform tests so that we'd be able to present evidence in our rebuttal case. And as it is, we're probably just going to get this in under the wire. I mean, we've really been pushing things as a result of not having had discovery notice of this. When counsel says that we took 5 or 6 impressions, just so the record is clear, and I don't necessarily think this misstatement is material on his part, there were only those 2 dates in which impressions were taken, and only one set of impressions was taken from the shirt. When impressions were taken from the genes, when he says 6 impressions, what he means to say, as I explained to him, is that the genes were impressed on a single piece of paper more than once. To quote Mr. Paradas, we went bing, 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 bing 6 times. But it was not 6 different occasions that these impressions were taken. that there are a total of more than one impression on a single sheet of paper that's approximately 10.5 inches by 9 inches, something in that order. Now, to respond to the so-called relief that counsel is requesting, first of all, in his letter brief, counsel says that I informed him that Mr. Diedrich was going to perform experiments involving the use of Mr. Goldman's genes, and he characterizes what happened to the genes as being an experiment, and suggests that that's the way I characterized it. I specifically said to him the same thing that I'm going to say to the court right now, and that's that taking a test impression or an exemplar is not an experiment. Whenever we conduct comparative analysis or impression or present evidence regarding impressions, regardless of what class of evidence we're talking about, we always have to have an exemplar. If it's handwriting, we get an example of the person's handwriting. If it's a footprint, we make an impression of the shoe on a piece of paper. If it's a tool mark, we make an impression of that. If it's a rubber stamp, we make impressions of that, and so on and so forth. We do that with all impression evidence. And in the case of clothing, we have to do the same thing. That's common sense, and that's also what experts will tell you. So we wanted to have these impressions, these exemplars, for the purposes of them being able to perform a comparison. That is not an experiment. It is not a test of any kind. It is not a test if I took the court's finger and made an impression for the purposes of being able to compare it to some other fingerprint. That's what we do with all comparison evidence. We take impressions, and that's what we did here. That's all we did here. And to characterize it as a test or an experiment is simply a complete mischaracterization of what I said to Mr. Scheck, a complete mischaracterization of what common sense and scientific experience would tell us. Now, for the requested relief of precluding us from taking these impressions or suggesting that we're somehow legally not entitled to take these impressions, we have a tremendous amount of experience in our legal system with the obligations of defense attorneys and prosecutors. Our legal system is very old. We have been conducting court trials and jury trials for about 750 years. Our common law is extremely old. And I would ask counsel to point to the court any statute from any jurisdiction, any case law from any jurisdiction in those 750 years that suggests or implies that the prosecution has any obligation whatsoever to refrain from investigating a case, from doing the tests that we require, experiments that we require. We don't. There is no such authority. And I think the court's orders recognize that, because when Your Honor made your ruling on August 26, 1994, in discussing People v. Griffin, you said that the prosecution must be allowed to investigate and prosecute crime, and due process does not require that it forego investigation in order to avoid destroying potentially exculpatory evidence, citing the Griffin case. And you also said that for the proposition that the prosecution is to be prevented from performing scientific tests that destroy evidence, that there was no authority to support that proposition, and that although it could not be condoned, that Your Honor was not going to decide prospectively what tests we could do and could not do. Under the authority that counsel cites and that Your Honor reviewed in your order, if the prosecution were to destroy exculpatory evidence in bad faith, then the court could apply a sanction retrospectively. But as the court recognized in its previous rulings on this issue in a different context.
Well, let's examine the specifics here rather than the general legal principles. What we have was testimony regarding impressions made by either the jean material or the shirt material, correct? That was from Dr. Lee.
Dr. Lee said that the jeans could not have made the impressions on the piece of paper in the envelope, and also said that the shirt could not have made the impressions.
All right, so in response to that testimony, you've asked your people to test the shirt and the Levi's or Levi-type material to see if that is in fact true, correct?
Well, I wouldn't call it a test. I'd call it, they made an exemplar of that, which will then be compared to the impressions on the envelope and the piece of paper. In fact, that comparison was done.
All right. Now, my concern, what was raised, is that one of the issues that was raised that causes me some interest and concern is whether or not the manner in which the impressions were taken from the Levi's and from the shirt in any way obscure or destroy any of the evidence that was on there.
Well, those impressions were some of the impressions were taken in my presence on August 31st. And those impressions that were taken from portions of the garments that did not have any observable blood or impression evidence on them. And although I believe it is possible to see a very slight yellow staining on the areas where the impressions were taken, it does not obscure or obliterate, even if it had been done on areas of the jeans that contain some blood pattern, it would not obscure or obliterate that, but it was not, Your Honor. It was done from portions of the garments which are not at issue in this case, which have not been testified to, which did not contain any observable evidence in this case.
All right, the other issue I'm concerned about is whether or not you've turned over all the notes that you have in your possession concerning this exemplar taking or comparison, whatever it is you have, and the photographs.
Yes.
And when was that accomplished?
It's been done in stages, Your Honor. And I don't know if I'm prepared to cite all of the dates now, but it was completed by yesterday. There were notes of Ron Raquel as to his taking of the test impressions that were turned over yesterday, but I actually turned over photographs of Mr. Raquel taking the impressions, and I turned over a statement from our investigator who witnessed taking the impressions significantly before then.
So since you intend on offering this testimony, what is it likely to show? What's your expectation of what Mr. Diedrich's testimony is going to be?
Your Honor, also yesterday afternoon, Mr. Diedrich faxed me the report, which I also sent to counsel as soon as I got it. And incidentally, I've been giving all of this information to the defense as quickly as I've received it, with the exception, as Mr. Scheck indicated, of the exemplars, which I immediately sent to the FBI, and those are on their way back to Los Angeles. To answer the court's question, what Mr. Diedrich is going to testify to is that he has done a comparison between the eyeglass envelope and the paper and the test impressions, and that the jeans can be included as having made the impressions on those items, that the shirt can be included as having made the impressions on Ronald Goldman's jeans. Your Honor, just...
Enough. Enough. We did enough. Oh, guys, thanks for coming out. We made it to the end of OJ. I shall see you all very soon. I hope you guys have a great day. Thanks for coming out, guys. Bye.